Afternoon. Call this hearing to order. Quorum is present. Without objection, the chair is authorized to declare a recess at any time. I want to welcome all the members and witnesses to today's hearing. I know that members have participated in similar virtual hearings this year with the full committee, but I'd like to remind participants of some of the items that we need to ensure that there's a smooth and engaging presentation moving forward. So if you're experiencing connectivity issues, please make sure you or your staff contact our designated technical support so those issues can be resolved immediately. To ensure that members and participants today can have robust engagement, I ask that members participating remotely continue to remain visible on camera for the duration of their participation in the hearing unless they experience connectivity issues or other technical problems that render the member unable to fully participate on camera. Today we'll be using a virtual timer to keep time. To keep that timer in your view, select grid or focus view, move your mouse over the second thumbnail from the right, click the white circle, select lock participant, and from the list of participants, choose hearing timer. This will keep the timer in your view. I think we're all becoming experts on this, but if you have any questions, let the staff know. When you're recognized, you will need to unmute your microphone. Just pause for 2 or 3 seconds before speaking so that your words are fully captured on the live stream. If you wish to have any documents inserted into the record, please ask for unanimous consent and have your staff email the document to veteransaffairs.hearings@mail.house.gov. It'll be uploaded to the committee document repository. Any questions about the procedures for the hearing? Hearing none, then we will proceed. I ask unanimous consent that Representative Rice be permitted to join today's hearing so she can speak about her bills on the agenda if she's able to join us. And no objection heard. That is so ordered. I now recognize myself for an opening statement. So at today's Oversight Investigation Subcommittee hearing, we will examine 14 bills. Oops, sorry, we had a little peripheral noise here. 14 bills, all of which will seek to improve our ability to better serve our nation's veterans. These bills would improve the department and its operations. Some would establish better accountability and oversight, while others would strengthen the civil rights protections for both veterans and VA employees. Several build upon the lessons learned during the last year of the COVID pandemic, and I'm pleased that overall the legislation shows the bipartisan nature of this subcommittee. Many are sponsored by members on both sides of the aisle. These bills were largely developed by majority and minority staff working together and based on what the subcommittee learned during previous hearings. While we haven't reached agreement on all of the bills, we have consensus over the intentions and direction of most, and I know that our dialogue will certainly continue. Today, we will hear from the Department of Veterans Affairs, and I was glad to see that the department will support many of the bills under consideration. For those where we don't have agreement, I understand that the department has engaged with us on the issues, and our work will certainly continue. The Office of Inspector General provides the subcommittee with important insights on many issues. In fact, some of today's bills are based directly on their findings, so I look forward to their comments. There are also many experts and stakeholders that have critical insights into the workings of VA. Many veteran service organizations, labor unions, and other experts have provided written testimony as well as having been consulted during the development of the legislation. So I just want to highlight a few of today's bills. We have several bills on the agenda which would improve VA's workforce, including Chairman Takano's HR 1948, the VA Employee Fairness Act, which was co-sponsored by more than 93 of our colleagues, and it would restore full collective bargaining rights for Title 38 employees at VA. I have a bill, the Improving VA Accountability to Prevent Sexual Harassment and Discrimination Act. It would require necessary improvements to the department's discrimination complaint system and reporting requirements for managers. The VA Equal Employment Counseling Modernization Act would bring much needed flexibility to the Equal Employment Opportunity Program by allowing VA to hire additional counselors. We'll also consider several bills on important accountability and oversight topics. We have 2 bills regarding the Office of Accountability and Whistleblower Protection, including my bill, the Strengthening VA Whistleblower Protection Act, and a discussion draft to make improvements to the Office of Accountability and Whistleblower Protection. Obviously, whistleblowers are essential to the department. They're vital for bringing to light waste, fraud, and abuse. And it's essential that we have a VA that is safe and welcoming for all and that whistleblowers will have their rights protected. The 2 bills may address the issue from different angles, but I know that Ranking Member Mann and I share the same goal. That's an OAWP that's trustworthy and good for veterans and the department. I hope we'll be able to work together on the best path forward on both of our bills, and I think today's hearing will be instructive on the right path forward. Representative Gallego has 2 bills which would improve accountability and transparency in VA. with the VA FOIA Reform Act and the VA Quality Healthcare Accountability and Transparency Act. We will also discuss a discussion draft to direct the Secretary to submit to Congress a plan for expending coronavirus pandemic funding. Representative Rice has two bills, including H.R. 2429, that's the VA Police Improvement and Accountability Act, and H.R. 2428, the Strengthening Oversight for Veterans Act. The second bill there, H.R. 2428, would provide the VA Inspector General with testimonial subpoena authority, an essential tool to fully investigate waste, fraud, and abuse. I look forward to hearing from our witness from the IG on how this would help them carry out their duties to better serve VA. I will soon introduce the VA Beneficiary Debt Collection Improvement Act, which follows on our work from the last Congress to ensure that veterans aren't responsible for overpayments that happen from no fault of their own. We will discuss supply issues, which follows last month's subcommittee hearing on the problems plaguing VA's medical supply chain. That's H.R. 2082, the VA Supply Chain Resiliency Act, which was introduced by Ranking Member Bost, which I was proud to co-sponsor along with Subcommittee Ranking Member Mann. This bill will have VA partner with DoD to participate in the War Stopper program to improve supply chain responsiveness and resilience in times of emergency. We will also look at H.R. 711, the West Los Angeles VA Campus Improvement Act, introduced by Representative Liu. I look forward to our discussion today. It's a long list. There's a lot of work to come, and I really hope we can have a constructive conversation here about these topics and more, and chart path forward that's going to allow us to pass legislation that can really help our end veterans that rely on these services and benefits. With that, I'd like to recognize Ranking Member Mann for 5 minutes for any opening remarks that he may wish to make. Ranking Member Mann, you're recognized.
Great. Thank you, Chairman Pappas. I appreciate you continuing the bipartisan tradition of this subcommittee by bringing 14 bills before us today, including many Republican proposals. While I'm generally supportive of the goals and intentions of many of these bills before us, I do have some questions about several drafting and technical aspects, which I hope to gain clarity on before giving my full support. As we learned at our recent hearing on VA supply chain, there were significant disruptions for needed supplies during the pandemic, and I fear that if we do not make significant changes, the VA will not be ready for the next emergency. Because of this, I was pleased to see that Ranking Member Bost bill, H.R. 2082, the VA Supply Chain Resiliency Act, is on the agenda today. I was proud to work with Ranking Member Bost on this bill, and I'm glad to join you, Mr. Chairman, in supporting it. By enacting this legislation, VA and DoD would enter into an agreement for VA to participate in the War Stopper program, which pays suppliers to hold emergency inventories on the government's behalf, which saves taxpayer money and ensures that vital supplies are available and at the ready. I believe that having access to DoD's War Stopper program is a better solution to VA supply chain challenges than the department's current plan to rely entirely on regional readiness centers, especially after learning that these regional readiness centers won't be fully operational until 2023, forcing the VA away from the industry standard by relying on antiquated supply depots. I'm also supportive of the draft bill on the agenda, modeled off my amendment that I offered during the full committee markup of the VA provisions of the American Rescue Plan. This bill would require a detailed plan, justification, and oversight of the $17 billion blank check that was provided to the VA in the American Rescue Plan. Additionally, this bill would require the VA Inspector General and the Government Accountability Office to audit and report publicly on VA's emergency relief spending. Regardless of how members voted on the American Rescue Plan, I think we all can agree that we need to ensure that every penny is spent to help the VA better serve our nation's veterans during the pandemic. I look forward to working with you, Mr. Chairman, to ensure there's a strict oversight of these funds. Turning to two other draft bills on today's agenda, I would like to comment on the legislation that seeks to reform the VA Office of Accountability and Whistleblower Protection, or the OAWP. This office was created by the VA Accountability Act in 2017, and while well-intentioned, I think time has shown that the office is duplicative and not serving the true needs of whistleblowers. With an annual budget of around $22 million, OAWP has cost taxpayers roughly $90 million in its 4 years of existence and has not returned anywhere near that value of its work. One proposal on the agenda to reform OAWP would transfer the investigative functions and subsequent funding from OAWP to the Office of Special Counsel, or OSC. The staff of the OSC have decades of experience in providing truly independent investigations of whistleblower claims, and I think this may be a better solution to give VA whistleblowers the support and the protection that they deserve. That being said, I know that you, Mr. Chairman, also intend to hold a hearing on whistleblower issues and OAWP next month. So I'll reserve my full judgment on what is best on the way to reform this office until then. Finally, Mr. Chairman, I do want to raise a concern with the text of HR 1948, the VA Employee Fairness Act. While partnerships between unions and management may be critical to VA success, this bill may go a step too far and have the unintended consequence that impact care for veterans. Under current law, VA healthcare workers have been barred from collectively bargaining over questions of medical care or competence. This rule came about as a carefully crafted compromise, and I'm fearful that the legislation would give private arbiters and other federal agencies authority to second guess the Secretary's decisions regarding a healthcare provider's conduct and competency, which could adversely affect the quality of care provided to our veterans. I thank you again I thank you the witnesses for being here, and I look forward to our discussion on how to improve the bills before us today. And Mr. Chairman, thank you. I yield back.
Well, thank you, Ranking Member Mann, for your comments. And I know we're also joined by full committee Ranking Member Bost, and I'd like to recognize him for any remarks he wishes to make.
Thank you, Mr. Chairman, and I'd like to briefly discuss two bills on the legislative hearing today. First, HR 2082, the VA Supply Chain Act. As the ranking member Mann has already said, this bill will help ensure VA is preparing to respond to the next emergency. And I'm grateful to you, Chairman, and also to the ranking member as the original sponsors. I look forward to making and marking this up quickly and sending it to the Senate. The other bill I would like to talk about is draft legislation to increase oversight of supplemental funding provided to the VA to respond to COVID-19. The VA received additional $17 billion in the American Rescue Plan earlier this year. I request justification from the VA to support this funding. Very little came, by the way. Then I asked why the VA needed additional money since roughly $10 billion in the CARES Act funding was still available. No one answered. Ranking Member Mann offered an amendment to oversee the use of those funds during the committee's markup of the American Rescue Plan. It was voted down on party lines. What I fear at that time, I can now confirm. Democrats gave VA a blank check to the tune of $17.1 billion. The draft legislation on the agenda today is nearly identical to Ranking Member Mann's amendment. It would establish strict oversight and reporting requirements over all remaining COVID supplemental funds. It would also require the VA Inspector General to conduct regular audits of these funds. Lastly, it would require the Government Accountability Office to conduct a complete review after all the funds have been spent. I believe that these requirements are appropriate given that we are talking about tens of billions of taxpayer dollars. We have a fiduciary duty. We need to do that. We should all expect full transparency on all of these funds as they're being used. I am pleasantly surprised to see the VA does not oppose this legislation, and I'm glad that you, Chairman, and our senator counterparts and others are interested in the language. I think there is a lot of common ground that we can find, and I look forward to moving on this important piece of legislation very, very soon. And with that, Mr. Chairman, I yield back.
Well, thank you, Mr. Bost. I appreciate your comments. We will now move on to our witnesses, and I will now recognize our witnesses for their opening statements. First, we have from VA, Mr. Jeffrey Mayo, Acting Assistant Secretary of Human Resources and Administration Operations, Security and Preparedness. He's accompanied by Mr. Hansel Cordero, Acting Assistant Secretary of the Office of Accountability and Whistleblower Protection, Mr. Ed Murray, Principal Deputy Assistant Secretary and Deputy Chief Financial Officer of the Office of Management, and Ms. Jessica Bongiorni, Chief of Human Capital Management at the Veterans Health Administration. Mr. Mayo is going to provide the testimony for VA, and I'll recognize you for 5 minutes, Mr. Mayo.
Good morning, Chairman Pappas, Ranking Member Mann, and members of the subcommittee. I'm here today with colleagues from the Office of Management, the Office of Accountability and Whistleblower Protection, and the Veterans Health Administration. Thank you for inviting us here today to present our views on a collection of complicated, important, and challenging issues, H.R. 1948, H.R. 711, and 12 other draft bills. I'm confident that we share the same goal, to serve veterans the best way we can. We support the majority of these bills. However, we have a few concerns and we wish to work with you on the language of some. H.R. 1948 addresses issues related to collective bargaining. Secretary McDonough has stated publicly and to our workforce that a unionized workforce is a strong workforce. VA views collective bargaining as a powerful means to achieve a strong workforce, which is seen as VA's #1 asset as we collectively work toward increasing greater access and better outcomes for our veterans, their families, caregivers, and survivors. We are actively engaged in the rebuilding of our relationship with the unions to provide a safe, inclusive, and equitable environment. However, we still have a few areas to work through and defer comment on this bill and will follow up with the committee. Regarding the Improving VA Accountability to Prevent Sexual Harassment and Discrimination Act of 2021, VA is committed to all VA staff, patients, and their families, caregivers, survivors, visitors, and advocates that each should feel safe in an environment free of harassment and discrimination. Secretary McDonough has been clear since his first day that he will not accept discrimination, harassment, or assault at any level or at any VA facility. Recently, we stood up internal working groups to focus on policies and accountability related to sexual assault and harassment, and will soon expand participation to external veteran organizations. We're actively reviewing proposals, including the possible realignment of VA's equal employment opportunity functions. Therefore, we defer comment on this act and will follow up with the committee. VA strongly supports the draft VA Equal Employment Counseling Modernization Act, which would eliminate the cap on the number of full-time VA employees providing EEO counseling. The staffing of frontline EEO professionals has not kept up with the significant growth of the VA's workforce in recent years. Eliminating this cap would greatly assist in timely resolution of conflicts at the informal stage before they escalate into formal complaints. VA strongly supports efforts to improve staffing, transparency, and accountability of law enforcement operations and supports many of the principles in the VA Police Improvement and Accountability Act. VA has undertaken positive steps in line with the goals of this legislation, including a body-worn camera pilot at multiple VA facilities. The pilot shows that managing a body-worn camera program is a very resource-intensive endeavor. It is unlikely we could meet the timelines in the bill to successfully implement the body-worn camera program as contained in the legislation. However, we welcome the opportunity to work with Congress to discuss implementation of this initiative over a time period that will ensure modernization is effective. VA strongly supports H.R. 711 for its ability to leverage a wider variety of non-federal funds and the provision of enhanced use leases to provide housing and to care for homeless and at-risk veterans on the West Los Angeles VA campus. VA supports legislative action that provides the Office of Accountability and Whistleblower Protection more autonomy to perform its critical statutory functions in an unbiased manner. And we would be pleased to continue working with the committee staff on refinements to the two bills aimed to strengthen and to improve the Office of Accountability and Whistleblower Protection. While VA strongly supports efforts to improve employee vetting, the department does not support the Strengthening VA Background Checks Act because there's already a significant government-wide effort underway that will fulfill the goals of this bill. The draft bill does not incorporate the upcoming requirements, policies, or procedures that will be implemented by all federal agencies this year during the transition from the current vetting process to the Trusted Workforce 2.0 initiative. VA largely supports the draft Beneficiary Debt Collection Improvement Act, which will limit the authority of the Secretary to recover overpayments made by the department and to improve due process accorded to individuals with respect to such recovery. The draft VA Quality Healthcare Accountability and Transparency Act of 2021 directs the Secretary to make important information available via one website. We believe that our current accesstocare.va.gov site may meet much of your intent, and we would be glad to discuss further with the committee. The draft VA Supply Chain Resiliency Act of 2021 would direct the Secretaries of Defense and of VA to enter into an agreement to allow VA to participate in the Defense Logistic Agency's Warstopper program. We believe this bill is not needed as VA is already leveraging interagency agreements with the Defense Logistic Agency. VA supports a robust and timely FOIA program and looks forward to working with the committee to address your intent to reduce the backlog of VA's complex FOIA process, but we do not support the bill as currently written. VA does not object to the draft Oversight of COVID Relief Funding Bill, as it would codify current VA practice. The VA also has no objection to the Strengthening Oversight for Veterans Act of 2021. The VA OIG can provide further insight into how such increased authority for the issuance of administrative subpoenas may impact IG investigations and operations. We look forward to working with the committee on opportunities to enhance VA's operations and the ability to carry out its mission. My colleagues and I are prepared to respond to any questions you may have. Thank you.
Well, thank you for your testimony, Mr. Mayo. Our next witness is Mr. Christopher Wilbur, Counselor to the Inspector General at the Office of Inspector General of the Department of Veterans Affairs. Mr. Wilbur, you're recognized for 5 minutes.
Chairman Pappas, Ranking Member Mann, members of the subcommittee, thank you for giving the Department of Veterans Affairs, Office of Inspector General, the opportunity to discuss our support for H.R. 2428, the Strengthening Oversight for Veterans Act of 2021. This legislation will strengthen the effectiveness of the OIG's oversight of VA programs and operations by providing our staff the ability to require the testimony of individuals who are not currently employed by VA. We appreciate Representatives Rice and Radwagen for introducing this legislation. The OIG supports this bill, and we have no concerns with the bill as it is drafted. Currently, the OIG can obtain documents and other materials from VA and other federal agencies, and VA employees and contractors must speak with OIG staff in connection with the OIG's work, except where an individual claims constitutional protection against compelled self-incrimination. While we can subpoena documents and materials from non-federal individuals and entities, the VA OIG cannot compel non-federal individuals and entities with potentially relevant information to provide testimony in support of OIG oversight activities relevant to VA programs and operations. H.R. 2428 would grant us the ability to obtain sworn statements from such individuals, including former federal employees of current federal contractors, employees of former federal contractors, and others who do not have an employment or contractual relationship with VA. We are committed to using this authority responsibly and support the external checks and tracking mechanisms Congress has included to ensure that we do so. First, the bill would require the OIG to provide the proposed witness with notice of our intent to issue a subpoena and an opportunity to testify voluntarily. Second, we must notify the Attorney General before issuing a subpoena, and the Attorney General has up to 10 days to object if the subpoena may interfere with an ongoing investigation. Third, it requires us to endeavor to arrange the interview conveniently for the witness. Additionally, our semi-annual report to Congress will contain information on any use of the authority. We would not be the first Inspector General with this authority. In particular, this bill would entrust us with the same tool afforded to the Department of Defense Inspector General. DoDIG has a very similar mission to the VA OIG, conducting oversight of extremely large contracting and healthcare organizations. H.R. 2428 provides us testimonial subpoena authority that is very similar to the authority granted to the DoDIG in 2010. The DoDIG has used its authority sparingly and judiciously. We understand that from 2010 through June 2018, DoDIG has issued only 7 testimonial subpoenas. The Department of Health and Human Services OIG also has testimonial subpoena authority, as does the newly created Pandemic Response Accountability Committee, which was established by the CARES Act last year. H.R. 2428, in fact, has more stringent notification requirements and reporting requirements and other checks than that required under the authority granted any of these other organizations. The lack of subpoena authority for witness testimony has hampered the OIG's oversight efforts on occasion. Our written statement discusses several healthcare inspections where our inspectors were unable to interview healthcare providers, such as doctors and VA managers, because they had left federal service before or during our reviews. Their refusal to discuss their actions could hinder our ability to determine the full extent of deficient healthcare practices. For example, a dentist and the chief of dental services left federal service during our review of improper dental infection control practices at the Toma VA Medical Center in 2017. As a result, we were unable to fully investigate the safety issues and learn more about the lack of supervision that potentially exposed 592 veterans to bloodborne pathogens. On another occasion, we investigated alleged contracting fraud related to an acquisition that was, ironically enough, part of the VA Stop Fraud, Waste, and Abuse initiative. The OIG sought testimony from a former employee who declined to speak with us. We ultimately found insufficient evidence to substantiate the allegations but enough evidence may have been developed to support a criminal referral or to recommend administrative action to VA if the OIG had been able to compel the interview. OIG oversight is only as good as our access to information and witnesses, and knowing that Congress has taken strong steps in the past to support the OIG's mission by providing appropriate authority to conduct that oversight. The VA OIG strongly supports H.R. 2428, the Strengthening Oversight for Veterans Act of 2021, and appreciates this subcommittee's consideration of this legislation. Chairman Pappas, this concludes my statement. I'd be happy to answer any questions the subcommittee may have.
Well, thank you, Mr. Wilbur, for your testimony. Appreciate those comments. And we will now go to the question portion of today's hearing. I suspect that we have the ability to do several rounds here, given the body of work that we're looking at and the number of bills before us. So as long as members have questions, I think we'll be looking to get to those questions. I will start by recognizing myself for 5 minutes here, and I want to ask Mr. Mayo and his team about an issue that he addressed in his opening comments, and that's legislation that I recently introduced called the Improving VA Accountability to Prevent Sexual Harassment and Discrimination Act. Obviously, this is a critical issue. Appreciated the comments that you had for us, but my question is about how we can move forward and deal with some of the issues that our subcommittee has identified. We recently had a joint hearing with the Women Veterans Task Force that revealed a number of shortcomings in the department's policies and procedures. The GAO testified during that hearing and provided a number of recommendations that led to the bill's provisions. So I know that you said VA is still reviewing the bill. When do you think we're going to see the department's comments that specifically pertain to the legislation?
Chairman Pappas, thank you for the question. I don't think I can provide a specific timeline, but I can assure you that we're aggressively working through what I think are some of the more administrative parts of the act, and we've set up internal working groups to focus on the policies and accountability, which I think is very important related to sexual assault and harassment. Within the next several weeks, we're going to be bringing in external veteran service organizations and state, local, and federal organizations to help with that task force that we've provided. We're also taking a hard look at our current way we've structured our EEO functions. Those are some of the things that we're working for, but I assure you we are not deferring any actions to get after sexual harassment, sexual assault, discrimination within the VA. We're certainly acting on those expeditiously, and we're working out some of these arrangements, and I hope to be able to come back to you soon so that you'll certainly have that information. Overall, the VA is committed to provide our staff, our patients, anyone that's walking through our doors or seeking our services with a safe workplace that's free of harassment and discrimination. I think we're exactly in line with those particular tenets.
I'm encouraged to hear the internal action that's underway, and I really appreciate your commitment to this. Now, in terms of the legislation, as I mentioned before, GAO's recommendations were the basis for the bill, and VA has already concurred with, I believe, all but one of those recommendations. That last one is still under consideration. So I really hope we can see a response soon. I think you can work with us in a timely fashion on this so that we don't see any delay in advancing this important piece of legislation. A second issue I want to mention before my time is up is the issue of veteran debt overpayments or veteran debts that have been accrued due to overpayments. That's an issue that we dealt with in the last Congress. Really proud that we passed the SHIELD Act into law, and the subcommittee needs to continue to go even further on this issue. That's why the VA Beneficiary Debt Collection Improvement Act will soon be introduced. Mr. Murray, I know that we now have agreement from the department that veterans shouldn't be responsible for overpayments that were made when VA made the mistake. The veteran did nothing wrong. There also seems to be general agreement on some of the other provisions. Is it correct to say that VA only has some small issues with how the language is drafted? And do you think we can get to yes on this?
I absolutely think we can get to yes, and they are very small issues. We look forward to actually having it codified, be measured, be held accountable. We've made a lot of improvements in the way we manage debt, and we look forward to making many more. So we welcome this legislation.
Okay, and I think we should note that testimony provided indicated that cost estimates were largely due to bringing some consistency and fairness to how VA collects these overpayments, such as eligibility determinations that were made incorrectly by VA. I hope the department's going to continue to work to improve and support the bill despite the cost estimates that are contained there. I think it's unfair to collect an overpayment from a veteran who has done nothing wrong. And, we look forward to continuing to partner on this important issue. With that, I'd like to turn things to ranking member or former ranking member Bergman of this subcommittee, General Bergman, for 5 minutes of questioning.
Well, thank you, Mr. Chairman, and thanks to everybody. There are good subcommittees and there are great subcommittees, but there are, I think, in the relevance of terms, good and great. How about just so essential and important? And O&I fits into that category because we touch everything. So just thank you for your leadership. I welcome the new, ranking member, Representative Mann, because we need good leadership on this committee. So having said that, Mr. Murray, I was glad to see that the VA has no objection to the oversight of COVID relief funding draft legislation. However, you said that it is, quote, subject to the availability of appropriations, end quote. Could you clarify? VA still has roughly $9 billion remaining in CARES Act funding and another $17 billion from the American Rescue Plan. The VA estimates that this total cost of this bill over 10 years is $631,000. That's like 0.04% of the 17 billion in the ARP. Can you explain to me how the VA would not have enough funding to carry out this legislation?
So that's a comment that the central office or the headquarters staff inserted there. Kind of think of it as being somewhat in the wrong bucket. I assure you that within what we call the general administration appropriation, we will make sure this oversight is done. We do it now currently. So this is not a heavy lift in terms of additional efforts. So I would ask that you not pay a lot of attention to that comment. We will work it out.
Well, thank you. Enthusiasm and sometimes leads to proofreading is more art than science, and my staff will attest to that. But anyway, thank you. Regarding we'll move on here. The VA Supply Chain Resiliency Act. Mr. Mayo, VA does not support the VA Supply Chain Resiliency Act as written because VA already has the authority to enter into agreements with DLA to join the War Stopper program. The intent of the bill is not just to grant authority, but also to make sure VA does join the War Stopper program. Therefore, if you already have the authority to join the program, when will the department enter into any type of agreement with DLA?
Thank you, Congressman Bergman. I think the part of the issue with this is the timelines and the process within DLA. We've actively engaged with them already. They are working with us on that. I think there is a very deliberative process, though, of how they work through to work with us on that. I know that we've had a recent hearing on that last month. I believe we have some folks that would be very available and would look forward to providing some other discussions on how we could get to the place that you want us to be, because we certainly want to be ready for anything that would come in the future. and certainly maintain that we have the types of supplies we have now. But I think any more detail than that, I would need to take for the record
Yeah,
and
what I
get
would
some of our real
suggest-
experts.
Yeah, what I would suggest is for us on the committee, a POA&M or a timeline, whatever you want to call it, whatever phrase you use, saying this is our next proposal. Give us an idea of dates, because time unfortunately has no relevance in DC in too many cases. You all can put meat on that bone of a timeline. That would be helpful. Lastly, in my last 49 seconds, Mr. Mayo, VA does not currently support the Strengthening VA Background Checks Act, but acknowledge that there is a, quote, significant government-wide effort underway that would fulfill the goals of the bill, end quote. Is VA supportive of this ongoing government-wide effort? And if so, what changes would the VA need to see in this bill to be supportive? And if you can't answer it in 20 seconds, please take it for the record, because we need to be able to have solid, consistent, timely background check procedures in place. So I'm just going to take it for the record. I see my time is about up, and being respectful of all of your time, I yield back, Mr. Chairman.
Well, thank you, General Bergman. Those were great questions for this great subcommittee. I appreciate your comments as well. With that, I'll turn things over to Mr. Lamb for 5 minutes.
Thank you, Mr. Chairman, and appreciate our witnesses joining us today. I have a bill included in today's hearing that would remove the limit on EEOC counselors within the VA. We've seen that there's about 38 of these for a workforce that is now over 400,000. So if my math is right, we've been relying on one EEOC counselor for more than 10,000 employees each due to the limit that has been in place, keeping that number from rising. It appears that this is the I guess, highest or toughest ratio among all cabinet level departments. So I think it does have to be fixed. My question for the VA witnesses really is twofold, if you can try to address it, which is, are you tracking currently the workload placed on every EEOC counselor? What can you tell us about that workload? And then secondly, once we remove this limit with this bill, do you have any sense of how many more counselors you would need to adequately meet the demand?
Congressman Lamb, thank you very much for that question. I'm glad to provide some details. We do watch the number of cases. I'm not prepared to discuss the caseload per worker with you at this point, but we do track that, and what we see is an upward trend. And what we understand the outcome of that is the counselors are not able to do some of that forward-leaning preventive type work to deal with any kind of complaints at early stages, or even prevent them from coming in as a complaint because their caseloads are high. What we have assessed at this point is that if the cap were removed, we would look to bring on an additional 36 more counselors as soon as possible to address this workload. And we think that would be a step. We also have some vacancies in our current authorization, and we're working very hard to get those filled so that we would have a workforce down the road, subject to congressional approval of this bill, that we would be somewhere around 86, 87 counselors that we would have in the workforce. Because as you correctly pointed out, the VA workforce has changed significantly since we began this program with our counselors. And we need to recognize that we need to keep up with some of the resources and allow them to do some of the things that they can do to provide a better functioning workforce for the VA.
Thank you. And in your metrics of the workload for the existing counselors, do you feel that you adequately are able to measure sort of quality and difficulty in addition to quantity? And are you able to see geographically where the need is greatest so that these new positions will be allocated to places that need the most help?
Yes, sir. We do have some ideas of the geographic distribution. each of these EEO complaints can vary. So we're probably less refined there, but I think that's an area where we can work on. But I do think we have a good idea. And if the direction you're going is where would we put these 36, we would certainly look for the places where the workload drives that and an ability to smooth that out. There may be some places that have exactly what they need now because they don't have as many complaints, but we would certainly take into account the workload, whether it's the complexity and volume of cases, and that would be looked at from a facility geographic perspective.
Great, thank you very much. I would just encourage you to consult the existing counselors themselves when you make these decisions. I have found in talking to VA employees, particularly the benefits folks, they have a way of understanding and explaining what the true workload is kind of beyond the numbers because everyone's claims and situation are different. And I think they would have some valuable insights into where help is needed the most. So thank you for your support of this effort and for working with us. And Mr. Chairman, I yield back.
Thank you. Next up, I'll recognize Ms. Radewagen for 5 minutes.
Thank you, Chairman Pappas and Ranking Member Bergman for holding this hearing today. Thank you to the witnesses for their testimony, and special thank you to Representative Rice for her work on HR 2429 and 2428, which I'm proud to co-sponsor. We've been working together for a while now, and I can't emphasize enough how appreciative I am of the bipartisanship that went into the most recent versions of these oversight bills. So, Mr. Wilbur, can you please tell us what you see as type of safeguards that are in place in HR 2428, how these will ensure that the Office of the Inspector General does not abuse this new authority? And can you please highlight some of the examples you listed in your written statement where your investigations have been hampered because your office did not have subpoena authority?
Yes, first, I think in terms of safeguards, it is important to note that this authority would not apply to our criminal procedures and our criminal investigators. Our criminal investigators work with the Department of Justice and U.S. Attorney's offices to conduct their criminal investigations. And when testimony is required for those criminal proceedings, that is done through the grand jury. So first of all, we are talking about the use of this authority in connection with our other oversight work. Principally, we see this as aiding our healthcare inspectors, whose role is to review adverse healthcare outcomes that happen at the department. One of the ways in which this will help, and this is highlighted in a number of the examples that we provided with my written testimony, is that we run into situations where we want to speak with a healthcare provider or a supervisor when we are undertaking a healthcare inspection related to an adverse outcome at a VA medical center, and that healthcare provider has already left VA employment. They've gone to the private sector and they are unavailable to us in terms of our ability to compel them to speak with us and provide information that we can then use to evaluate the healthcare provided and to make recommendations to the department about how to improve healthcare going forward. That's one principal area. In addition, the VA is increasingly relying on community care through a number of pieces of legislation that have been passed in recent years. And so those community care providers are, again, they are not VA employees. They are generally unavailable to us as well for us to compel their testimony. If they've treated a veteran and there's an adverse outcome, we want to be able to speak with them as well. And finally, the third area where this is principally helpful, and this goes beyond just our healthcare, but other administrative investigations we may undertake, is with respect to contractors. Employees of contractors, if they leave that contractor, we cannot compel them to testify, or if the contractor no longer has a contract with the department, or if they were just sort of undertaking an effort to get a contract, those people are unavailable to us. And there's often fraud involved in those situations where we want to be able to speak with a contractor, employee, or others in order to understand what happened and to be able to make recommendations to the department about how to potentially take disciplinary action against current employees, or to at least safeguard itself against fraud in the future.
Okay, my time is short. Do you support the draft bill on the agenda that would tighten up the background checks required for certain contractors at VA facilities?
We do support that bill. We think it's important that that those background checks are undertaken. We have through our audit work um, uh, identified for the department this as a potential issue. We sent an administrative memorandum to the department highlighting that as a potential issue and really highlighting the fact that given the backlog that has taken place, over the last year, that it may be difficult for the department to really work through that and obtain background checks for people that have been brought on during the pandemic.
Thank you, Mr. Chairman. I yield back.
Well, thank you, Ms. Radewagen. I'll now recognize Ms. Luria for 5 minutes.
Well, thank you, Mr. Chairman, and thank you to our witnesses here today. I wanted to reference back to the full committee hearing that we had on March 25th, and Secretary McDonough was asked about the implementation of President Biden's executive orders, which rescinded President Trump's harmful anti-union executive orders. And the secretary responded by saying that the VA is taking steps to correct this in the next weeks and days. And I spoke to the secretary and understand that he recently put out a directive reversing this policy, which I applaud. However, it's been almost a month now, and I'm still hearing from my district about how official time and office space at the Hampton VA have not been restored to how they were prior to President Trump's changes. Ms. Bongiorni, can you speak about why there's still a delay?
Yes, thank you, Congressman, for the question. We are working with facilities at the local level to address any issues as they come up. So there are 3 main areas where we're still working to get to full resolution and rescinding the executive orders. And those are official time, returning space, as well as providing IT equipment and accounts. And so as each facility goes through what local procedures they need to go through, what we're generally finding is that sometimes there are miscommunications that are leading to some of the challenges there that we are working through individually as they come up. So, for example, there may be situations where space has been repurposed for clinical care. And in those cases, we need to find alternative space that is amenable for our labor partners. And so it just takes a little time to work that out or to provision new IT equipment and do the wiring and such. So we are well on our way to being complete. We are close to 90% across the entire system for completion of each of those tasks.
Well, thank you, and would appreciate if you could just take a look into the situation at the Hampton VA and report back to our office if there's any further delays anticipated there. My second question is about the bill on the agenda today, the VA Employee Fairness Act, which allows Title 38 employees such as registered nurses, doctors, physician assistants to file a grievance if there is a discrepancy in their paycheck. It was brought to my attention that Title 38 employees in my district, a doctor, was unable to file a grievance after not receiving a bonus and trying to address the issue through other channels. According to the information received by the physician, there was nothing that the physician could do because of the current statute. Do you believe that doctors and nurses who often work overtime taking care of our veterans should be allowed to file a grievance if their paycheck is incorrect?
That's an important question. We do think that all employees have the right to have accurate and timely compensation. And if you would provide us specifics, we'd be happy to work with any impacted employee if they're having a pay issue. Typically, we have a variety of other mechanisms that employees can use to get their pay issues addressed, whether that is directly through their HR chain or raising it up to us here at the headquarters level. So we'll be happy to assist.
Well, thank you. And I'm a supporter of Chairman Takano's bill to restore collective bargaining rights to all VA employees. I know you're looking into this language, but I wanted to bring this situation to your attention as an example of how it's been impacting in my district. And I hope that the Secretary will continue his support for all of our frontline healthcare professionals. And I yield back the remainder of my time. Thank you.
Well, thank you, Ms. Luria. I will now turn things over to Mr. Sablon for 5 minutes.
Yeah, thank you. Thank you very much, Mr. Chairman. It's just a wonderful way to discuss legislation, and I hope other committees could learn from this subcommittee. Congratulations. I do have, one of the issues that I have, let me ask my question first. Secretary Mayo, sir, I understand that the minority members have a discussion draft of a bill to increase oversight of coronavirus pandemic funding. I agree with the main goal to increase oversight. Congress needs to have a much better understanding of the plans for how these funds are spent and how these funds should be spent. And I'm particularly interested in how the VA has and will use these funds to help veterans in my district, the Northern Mariana Islands, and now other insular areas. I often hear of the VA's plans and initiatives for the several states, DC and Puerto Rico, but rarely hear specifics for veterans in the insular areas of American Samoa, Guam, the Northern Marianas, and the US Virgin Islands. My question is, has VA determined its budget plans for the increased funding that Congress provided? And do these plans detail what the increase of funds will mean for veterans in the Northern Marianas and the other island areas that I mentioned?
Congressman Sablan, thank you for the question. I assure you that we have every intent to make sure that the same type of access, the same type of outcomes that we're working for all veterans would apply to those veterans in your district and area in the Marianas. I would ask that maybe Mr. Murray could explain a little bit on the funding. I don't have particularly those details. We could certainly maybe take it for the record. I'm not aware of the exact plans at this point.
Yeah, I mean, I don't mind that so long as eventually we get the information especially for the other insulators. And while I have you and I have the Chairman Pappas here and General Bergman, one of the issues I faced here in Congress, and this is going on for 12 years, is, among the cornucopia, the huge abundance of federal regulations and federal programs that apply throughout our nation. There is always that confusion of whether one thing applies to the territories as well, or one thing applies to some territories and not others. Is there a way where we could set up, as a workforce or task force, and not too many, just to look at the programs that apply to the territories and ask why the rest that don't apply, why they don't apply, and if there is rational in maybe making them apply, that as well. Secretary Mayo, I appreciate your statement that you want to make sure that the services that apply to veterans in the states apply to the territories. It's not exactly accurate because, and there may be reasons behind it. I'd love for those things to apply, including get the VA to set up a CBOC at the very least in my district, or a vet center even. That's not happening. I got the commitment of Secretary, Secretary Shin, can I have the name? Secretary, before the last secretary he had to leave his job because he went and watched, I guess he's a tennis fan. I had his commitment to set up a vet center, and that's still not happening. Is there a way we could set up something so we work and find out, do a census maybe of the program that applies to territories and look at others that don't, and if there's no rationale to make them apply, then we'll leave it alone. But if there are, maybe we could continue working and eventually get the services, Secretary Mayor, that you said that are available to veterans here in the 50 states, the several states. apply to the territories as well. Thank you for everything that your department does for our veterans. And Mr. Chairman, I yield back.
Well, thanks for those comments. That's an important issue to work on. I think we have additional questions, and so we can open up another round. And I wanted to go to Mr. Cordero. It's nice to have the opportunity to have you in front of the subcommittee. You know that we've had conversations, and the issue of OAWP has been a longstanding issue for this subcommittee. Wondering if you could talk about the current relationship between OAWP and the department's Office of General Counsel, and how conflicts of interest are currently prevented between OGC and whistleblower cases that come forward.
Thank you, Chairman Pappas, and thank you for allowing me to present to this subcommittee. So one of the critical points effectively is whistleblowers need to be able to speak truth to power and need to be protected from retaliation. And part of that occurs by the avenues where they can raise their whistleblower disclosures, whether to OAWP, the Office of Special Counsel, the Office of Inspector General. There are different offices for them to turn to. With regard to the Office of Accountability and Whistleblower Protection, we take our responsibility to protect the identity of whistleblowers who come to this office seriously. We have, as part of our processes, if a whistleblower wants to remain confidential and not have their identity disclosed outside of OAP, we have processes to prevent that from occurring. We have processes to accept anonymous disclosures from individuals. With regard to the Office of General Counsel, we rely on them in the way the department is structured for legal advice. And they provide us legal advice with regard to legislation, policy issues. And we have, at least in terms of our cases, what we do is we basically undergo a review internally. We don't send those cases to OGC for legal review, again, in order to preserve the confidentiality of whistleblowers. So there are some potential conflicts that arise, and we've taken actions effectively with the Office of General Counsel to mitigate those conflicts. And when there is allegations, for example, against an OGC senior leader or a disclosure made by an OGC employee, obviously that would be a conflict that we would work closely with the General Counsel on to ensure that the whistleblower's identity remains protected. So those are sort of some mitigative efforts we have undertaken in our work with the Office of General Counsel. We also, again, take the independence of our investigations seriously. We approach investigations in an unbiased fashion. I heard from Ranking Member Mann a little bit about duplicative efforts from OAWP. We have undergone substantive changes over the last 12 months, and we have results to show for it. For example, in the last year, effectively, we have issued 98 recommendations, 39 disciplinary recommendations for senior leader misconduct, 29 disciplinary recommendations for VA supervisors for whistleblower retaliation, and 30 non-disciplinary recommendations, for example, corrective action for whistleblowers. All these recommendations and all this work occurs internally within OAWP. And we basically develop the reports of investigation. Again, we would rely on OGC for legal advice, but we typically, once an issue is spoken to in the law or in VA policy, there's no need to sort of, again, consult on each investigation, and we don't do so. So again, we investigate independently, we prepare these reports of investigation independently, and we make these recommendations in an unbiased fashion as the law requires.
Well, thanks for that overview. That's important. I know things have come a long way since the office was first established. We all know there's more ground to cover, however, and the bills that have been submitted by both the majority and minority, I think, come at this from a different angle. But I think we share the same value and belief about ultimately how we should be treating individuals that come forward with this information and ensure accountability and independence. So I'm hoping that we can come up with a bipartisan solution as we move forward on this. I think that's really critically important. One of the other things I wanted to get at, and Ms. Radewagen raised HR 2428, the subpoena authority, and maybe I could ask our VA witnesses about this. Am I hearing correctly about your support for the legislation? You indicated in your opening and in the testimony submitted, some positive comments about it. I'm just curious if this is legislation that you support.
Chairman Pappas, yes, the VA does support that legislation.
Okay, thanks for clarifying that. I'm short on time, but I can try to squeeze one in about VA police. This is an issue that Ms. Rice has worked on. And Mr. Wilbur, I'm wondering, does VA still have work ahead to fully address your findings in terms of the VA police issue?
Yes, they do. And I think we have a number of open recommendations from our previous reports, including on the fundamental question of how the police force should be constituted and operated. Should it be, part of VHA where medical center directors have control over their local police force, or should it be something that's controlled through central office? I think that's sort of a fundamental question, as well as one of the recommendations we have open, and it's reflected in the bill as well, is ensuring that an accurate staffing model for police at each medical center is undertaken, so that they know what they need to accomplish their goal.
Well, thanks. And I would note VA's support that it has voiced for Congresswoman Rice's legislation, and I look forward to helping to work out the details on that with her and VA moving forward. My time's up, obviously, so I'll turn things over to General Bergman.
Okay, we have to wait a couple of seconds to make sure we're live. All right, all of these, Mr. Mayo, are going to be directed to you, not at you. Sound like but the point is in your direction. How do you respond to those who say that one of the missions of OAWP to investigate whistleblower complaints is duplicative of the mission of the Office of Special Counsel?
Thank you, Congressman Bergman. I guess I would highlight some of the things that Mr. Cordero has already said, that the need for that to be independent. We certainly work in HRA, OSP, Human Resources Administration, where we have some of the personnel sides of that. But I think there's probably a relationship there that's outside of that one that we have with them. But I do think it's important for the OAWP to have some level of independence.
Well, one of the things, and this is not a perspective of either Democrat or Republican, but it's one thing to have overlap in bureaucracies. It's another to have overlap to the point of actually limiting the ability of each of the offices to function, and that's a challenge of any bureaucracy. So anyway, next, can you please provide us more details on your issues with the draft police reform legislation, especially the section that requires transparency on police actions nationwide and concerns about the amount of time it would take to implement the body-worn camera provisions?
Yes, Congressman Bergman, thank you very much. We certainly share the same aims, I think, of that legislation to provide more transparency and accountability. We have, for the last number of years, done some pilots to test body cameras in Kentucky and Illinois. We currently have going on in Baltimore, Phoenix, DC, and New Jersey facilities. One of the things that we've learned from that is that a body camera program is very resource intensive in terms of not just the equipment, but the storage of it, the policies, procedures, and so forth. The biggest thing that we see challenging us with that is the amount of time to implement that. We have 144 different police departments, approximately 4,000 police officers spread across the country. And I think the timing of that is significant. Similarly, though, I think we have a data system called Report Exec, which provides a lot of the transparency and our ability to account for actions that are going on across the country at the various sites, but that does not translate to the same kind of a data system we would need to have for body cameras. So while report exec does most of what we need to do to meet some of the intent of the bill as I read it, it would not meet what we need to do to support a body camera program in terms of the storages and the policies and procedures. But we'd certainly be glad to continue working with the committee and the sponsors to address some of those timing concerns so that we can get a plan to implement this, because it is something that we support.
Well, again, we're not creating new technology. Body cameras existed before the VA started to look at them. Training, the procedures of implementation and inspection already exist in other organizations. We don't need to build another unique set of bureaucratic functions within the VA. Last question. On several of the proposals on today's agenda, including those related to harassment and discrimination and collective bargaining for Title 38 employees, the department has deferred judgment and official views until a later time. Can you give us an estimated timeline for when? Again, kind of go back to my very first question. POA&M timelines. Can you give us a clue? Give us a target.
I don't have specific dates I can give you for either of those, sir, unfortunately. I can assure you that we're aggressively working towards that. There are just a number of things, and it's contained in the testimony that under Secretary McDonough's leadership we've done to move forward on the 1948, on some of the actions there, and on the deferment on the sexual harassment act that we spoke about earlier. That is probably nearer, but we still have to work through some of those things to work some of the organizational things. I don't think we're apart from a lot of the major focuses in either bill, but we do have some things that we need to work through that I think that we're aggressively doing, and I would hope it would be sooner than later.
Well, again, timelines, even if it's only an 80% timelines, help all of us and our staffs. And we're not using them as punitive. There are a lot of cases, especially on new, and I see I'm over my time, but on new projects or things we're trying to do differently, everybody needs a little flexibility. But if we can agree upon a basic timeline with some goals, then that helps us from continuing to ask the same questions over and over again, because we'll see something from you. With that, Mr. Chairman, thank you, and I yield back.
Thank you. Mr. Sablon, you're recognized for 5 minutes.
Yeah, thank you. Thank you again, Mr. Chairman and General. Mr. Mayor, I'm going to go back again to, because I didn't hear any response from you. Actually, the secretary was Secretary Shokin at that time, who gave me a commitment that we're going to set up a debt center in the Marianas, and we still don't have one. We really would like one. So, but on the other issue that I was talking about, is there a possibility of setting up some kind of arrangement where your department would look at the several programs that apply to the insular areas, the territories? Again, I'll go American Samoa, Guam, the Northern Marianas, and the U.S. Virgin Islands. And among those issues, find out why other programs do not apply. There are rationals, I'm certain, that some programs don't apply, but if there are programs that has no, major obstacle, we could look at getting those to apply. Is this something that your office could do, or should I ask the chairman to help me and we'll go to GAO, Mr. Mayo?
Congressman Sablon, thank you for the questioning, but yes, I think the VA can commit to discuss with those things with your office, to get a little more definition. I think it would be helpful to us as to this particular issues that we can do to provide a response back to you on that, whether we do that as a question for the record or however you'd prefer to do that in some consultation. It's not my specific office, but certainly in the VA, we would have the capability to discuss that with you.
Yeah, okay, thank you. So what's convenient for you? Work with our office directly if you want anything, but let's get this moving. Number one. Number two, and I have a question for Mr. Wilbur, right? Inspector General, Office of Counselor. I have a question for you, Counselor. I submitted a report about the one staff that you have in the Marianas, an administrative staff. I requested, and it was, I don't think it's a whistleblower because I was the one who submitted the report asking for an Inspector General review of her performance and how she would, because she's not happy with me, but how she would tell people who come to see her, that I am a bad politician. I don't know why she said. I mean, she's not happy with me, she cannot vote for me, but she doesn't have to tell others that. I don't remember ever receiving a response to my request. Would it be possible, Mr. Bluberg, to look into that and see if there was something done, and if it did a response, I appreciate that. It's at least 4 years request.
Yes, sir. I'm not familiar with the request, but I will look into it and we'll respond to your office.
Thank you. Mr. Chairman, I have 1 minute left in my time. Either you, Chairman Pappas, or maybe General would need it. I yield to whoever needs it. If not, I yield my time back.
Well, thank you. I know I have two quick ones to ask, and if anyone else has an additional question, we will entertain those. I share the concern that Representative Bergman mentioned about the timeline issue in a variety of different areas, including the War Stopper effort. And I'm wondering if VA will share the interagency agreements it's using to outline its cooperation with DLA on War Stopper. And further, if VA will commit to working with us to establish reasonable timelines for the bill's reporting requirements on the types and quantities of items to be included in War Stopper and justifications for items that are held in regional inventories versus the War Stopper program. I think these provide critical opportunities for the subcommittee to conduct oversight of the VA supply chain issue, which we have recently done a hearing on, and we have learned through this pandemic is something that we can't look away from. We've got to continue to dig into this issue. So I'm wondering if you have thoughts on those timeline issues as it pertains to the matter of War Stopper and DLA.
Chairman Pappas, thank you for the question. We'd be glad to have a further discussion with the committee to provide more detail on the timelines and some of the details that you've just asked for, but would take that for the record at this point, the details.
Okay, well, we'll follow up on that, and we really look forward to your response. We do have an upcoming hearing on May 6th dealing with diversity and inclusion in the workplace. I know Chairman Takano and I have submitted a letter to the Secretary that outlined some of our ideas to support a more diverse and inclusive VA workplace in the near term. And I'm wondering if you could outline some of the efforts that VA is planning to undertake over the next year to bolster diversity and inclusion. And similar to the issue of lifting the limit on EEO counselors, are there other ways that Congress and the subcommittee can assist VA in achieving its workforce goals?
Thank you, Chairman Pappas. We have launched a 120-day effort, a task force, if you will, to address diversity, equity, inclusion, access within VA, and they're looking at a number of different avenues. Things that will be discussed, I would imagine, would be internships to work with that. We're also working on some barrier analysis working groups. We've started one of those. We'll continue to work those and for the various areas over the next year. We're certainly trying to bring together the experts from inside VA as well as some external VA with the VSOs and so forth. That effort is early. Parts of my team are involved in that, but it does spread across the VA. And that's just one of the things that the Secretary is doing to try to lay a path forward on that. So I don't have lots of specific timelines with those, but we certainly would have that coming out of this completion of this task force, which I think would be coming up sometime in the summer.
Well, might be a little bit later than we were hoping for, and I would appreciate if you could take a look at the letter that Chairman Takano and I sent over and see if there's a more detailed response that you can provide in advance of our May 6th hearing. I think that would be helpful for our work.
Yes, I think we can have some more specific answers for the May 6th hearing.
Well, thank you for that. I don't have anything else. General Bergman, I'll turn it over to you for additional questions.
No, I'm good. Thank you. Thank you, Chairman. Thanks to everybody who participated today. Open dialogue and, the agreement that we can have to be, if you will, transparent, and just to hit that, idea one more time of providing timelines. Don't worry that they're showstoppers, because timelines are meant to change when conditions change. But we need to have agreement to move forward towards outcomes. So thank you.
Well, thank you. Thanks for taking over the reins here. It's great to see you. And I want to thank all of our witnesses from VA and OIG for joining this hearing today. I think it's been a helpful and constructive conversation. We want to make sure that continues because I think through that process, we can continue to improve this legislation and get it right for the veterans. That's what it's all about. So all members will have 5 legislative days to revise and extend remarks and include any extraneous materials. And without objection, the subcommittee stands adjourned.